Hello everyone, my name is Lalit Soni and you are watching Recap 2024 quiz. If you remember, we have come up with the series that is Recap 2024, based on which we have come up with the practice series wherein we will be discussing some of the MCQs over here based on the discussion we have held in the Recap 2024 series. So if you have not watched it, you can go directly visit our YouTube channel. There will be a playlist called Recap 2024 and you can watch these videos. Now let's start with the MCQs over here. So here we will be starting with the major judgment MCQ number 1. Consider the following statement. Statement 1 says that the right of minorities to manage their educational institution is absolute and free from the state regulation. Now if you look at the statement, can it be true? Because obviously they are saying that the right is absolute. Even the fundamental rights are having some kind of restrictions. Okay, so that is why this statement is incorrect. Coming to the next one, Article 30 of the Constitution allows minority to establish and administer educational institutions. Now this is correct. So you can say that statement 1 is incorrect. Statement 2 is correct. Option D would be your right answer over here, wherein it is written that statement 1 is incorrect and the statement 2 is correct. Okay. Now where it has been discussed, we can see that there was this judgment, that is Anjum Kadari versus Union of India case. Okay. In that particular case, the Supreme Court has upheld that the Uttar Pradesh Board of Madrasa Education 2004 that regulates the madrasa education standards and clarify the right of minorities to manage their institution is not absolute but subjected to the state regulation. So basically here what they are saying, that one thing, the act, that is Uttar Pradesh Board of Madrasa Education Act, that act is constitutionally valid. There are certain things which were there that has been violative of the central legislation, that has been, you can say, scrapped off, but that act is constitutional. Second thing what they have said, that though you are having these rights wherein you can manage and administer your own educational institution, but they are subjected to some kind of regulation by the states. Okay, so that particular right is not absolute right. Coming to the next part over here, the ruling confers that the state's authority to regulate education standards even in the minority institutions under Article 30. Now Article 30 of the Constitution states that the right of minorities to establish and administer the educational institutions, that is given in the Article 30 of the Indian Constitution, and that is a fundamental right. Okay. Now coming to the question number 2, before that I would like to tell you that we are offering IAS foundation courses for prelims as well as mains. Offline batches are there along with the free online facilities in the English medium. Admissions are open at our centers, that is Prayagraj, Noida, Lucknow, Jaipur, Indore and Karol Bagh. Okay, so you can directly visit the centers and get yourself enrolled, or you can call on this number, that is 87501 87501. Okay, now moving further, question number 2, caste based discrimination in the prisons violate which of the following article of the Constitution? Article 25, 26, 30 or 23. Now if you talk about Article 25, that is related to your right to freedom of religion. Now Article 25 and 26 are related to the freedom of religion. Then coming to the Article 30, that is related to the minority institution, education institution, etc. So that is also not true. So Article 23 is the right answer over here, that is related to right against the exploitation. Okay, so herein they are saying that caste based discrimination in the prisons violate which of the following article? That is Article 23. And where it has been discussed, so basically in the case, that is Sukanya, Shantha versus Union of India, wherein it was said that the caste based discrimination in the prison modules or the manuals which are there, which are basically, you can say, regulating the conduct in the prisons, that is you can say not valid, or you can say that is unconstitutional, because in that particular manuals there were certain provisions which are doing some kind of caste based discrimination, because wherein there was some caste which has been mentioned, or there are some groups which has been mentioned over there in the manuals, and the work distribution in the prisons were done on the basis of the caste, and that is why the Supreme Court in the Sukanya Shantha versus Union of India has said that that particular provisions are, you can say, constitutionally invalid, and ultimately government has to change them, and the Supreme Court has given 3 months and government has already changed them. Okay, when we are talking about the central government. So here you can say the Supreme Court ruling in Sukanya Shantha versus Union of India emphasized that the caste based discrimination in the prison is unconstitutional. Article 23 of the Constitution specifically prohibits the traffic in the human beings and the forced labors. By extension, it includes the prohibition of any form of forced and the bonded condition of labor, which can be interpreted as the inclusive of the caste based discrimination as well. Okay. Now the thing that if you are belonging to a particular caste, you have to perform a particular kind of work, that is the restriction which is there. Now this is unconstitutional, okay, and that can also be considered as a forced labor. So that is why it is against that. Under Article 23 we have a right which is against the exploitation, so that is why it is under Article 23. Now coming to the question number 3, consider the following statement regarding the right to a speedy trial in the context of the prolonged detention. Statement given are: the right to a speedy trial is derived from Article 21 of the Indian Constitution, which ensures the right to life and personal liberty. Now this is totally correct statement. Now coming to the second one, the Article 32 provides the right to speedy trial as means of constitutional remedy for the right violators. Now that is not true over here, because when we are talking about the Article 32, that is dealing with the constitutional remedies, or you can say there are some kind of remedies which has been given by the Constitution to the citizens whenever their fundamental rights are basically you can say being violated, okay. But when you are talking about right to speedy trial, okay, so that can be considered as a fundamental right under another right. We will be talking about that as well. So here statement 1 is correct, statement 2 is not. Option A would be a right answer, that is only 1. Now when we are talking about this speedy trial, there was this case, that is Mubarak Ali versus state of Uttar Pradesh. Supreme Court observed that the prolonged detention without the trial undermines the constitutional right to speedy trial, which is a part of right to life and liberty under Article 21, okay. Now when we are talking about the prolonged detention, that is against the liberty, so that is why you can say that that is under Article 21. Now Article 21 is the very long list of you can say rights which has been mentioned under there, or you can say when we are talking about the Constitution does not talk about all these rights, but the thing is the interpretation which has been taken by the Supreme Court has made it you can say a very extensive fundamental right, okay. Now Article 32 provides the right to constitutional remedies which allow individuals to approach the Supreme Court directly in case of fundamental right violation, but does not explicitly mention the right to a speedy trial, okay. That is basically interpreted under Article 21. So that is about it. Now moving further, question number 4, under which constitutional article does the right to health encompassing a consumer's right to be informed about the product quality falls? Article 19 1G, Article 21, Article 32 and Article 40. Now here Article 21 would be a right answer. Now how? Because Article 21 is talking about right to life, okay. Now right to life include right to health, okay. So that is why you can say that Article 21, as I told you that Article 21 is very extensive and Supreme Court has taken various interpretation of this particular right, okay. So option B would be your right answer over here. You can see recently in the Indian Medical Association versus Union of India case, Supreme Court has recognized the right to health as the integral right to life under Article 21 of the Indian Constitution. The right extends beyond the mere absence of the disease, encompassing the right to make informed choices regarding the health, which includes the consumer's right to be informed about the quality of the product and services of affecting their health and well-being. So basically if there is an advertisement etc which is misleading, so that is violation of the right to health, okay. So that is there, and they have said that when we are talking about the some kind of misguided advertisement etc, so the person who is making this advertisement, the celebrity who is been part of this advertisement, or the person who is endorsing such product, these are all people who are responsible for that, okay. So that is question number 4. Now coming to the last question, that is question number 5. Consider the following statement regarding the roles of president and the parliament in the classification of tribes and the caste. Statement 1. President has the authority to initially notify the tribes and the caste as scheduled under Article 341 and 42. So basically they are saying that initially there will be a list which will be made by the president, okay, under Article 341 and 42, wherein he can identify the tribes and the caste as scheduled, okay. So that is the statement which is correct. Now coming to the second statement, any changes or the reclassification of this list require a constitutional amendment. Now this is incorrect. This can be done by the parliament, but constitutional amendment is not required. So okay, so option A would be a right answer, which is saying that only statement 1 is correct, okay. I hope that is clear. Now this explanation is given over here. Recently in the state of Punjab and other versus Davinder Singh and others case, the Supreme Court has upheld the sub-classification among the scheduled caste and the scheduled tribe to ensure the benefits reach to the most disadvantaged of people. Then coming to the next one, the president does indeed have authority under Article 341 and 342 to notify which caste and the tribes are considered as scheduled. and if there is a change which is required, that can be done by the only an ordinary legislation in the parliament and not by a constitutional amendment act. Okay, so I hope that is clear. I hope you were able to answer all these questions, and if you had any kind of you can say problem or the difficulty, you can go and watch the video that is related to the major judgments in the recap 2024 series. Okay, now there is a practice question for you. Consider the following statements. Statement 1 says that the Supreme Court found the electoral bond scheme unconstitutional due to the issues of transparency and the accountability. Statement 2 says the Article 19(1)(a) of the Constitution ensures the freedom of the speech and expression, including the right to information. Okay, which of the following statement is correct in respect of the above statements which are given? So you can read all these things and accordingly you can answer to me in the comment box. Okay, now second question for your practice, which is given over here. The denial of reproductive rights or the right to when we are talking about the procreation, so denial of the reproductive rights including the right to abortion contravenes which constitutional article as affirmed by the Supreme Court? Article 14, Article 21, Article 19 or Article 26. Okay, so you can attempt these two questions and answer to me in the comment box. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.